whether the President's authority extended that far. Let me move on to the question of the attorney-client privilege. Where you have the constitutional right to counsel, which we all agree involves confidentiality, and where you have the clear-cut historic obligation of the government to prove its case, what is the justification for coercing a waiver of the attorney-client privilege? That is what happens in real life. In the KMG case, where the federal court in the Southern District of New York has found excesses by the government, where you have a clear-cut conflict of interest between the corporation, which is being asked for a waiver, and the individual employee who may have contractual rights to counsel. What is the justification? Can you sparse it as the Thompson memo does and the McNulty memo, that if it's a fact question, it's decided by the Assistant Attorney General. If it's an opinion or judgment question, it's decided by the Deputy Attorney General. Isn't the attorney-client privilege so valuable that we shouldn't tamper with it by what has worked out to be coercive waivers of the privilege?
Well, I think we share the belief as former prosecutors and me as a former judge that the attorney-client privilege is vital to clients getting advice from their lawyers. I think also we share the view that it should not be tampered with or coerced out of existence. And I understand that you visited with the Attorney General and that he is going to be sending you a letter that will include real significant proposed changes.
How soon?
Within a day or so.
Will we have a memo that we can work from to get your position? Because I know
yes.
Your public statement was that you're satisfied with the McNulty memo. Are you satisfied with the McNulty memo?
I think my public statement was that the McNulty memo could be used in a proper way. There's no such thing as a memo that achieves perfection. And there are adjustments in the McNulty memo that can and will be made, and the deputy proposes to make them. In particular, we will no longer measure cooperation by waiver of the attorney-client privilege.
Well, are we going to get more than a letter, or are we going to get a memo that we can work from to try to see if we can resolve this on a compromise and accommodation, or are we going to have to move forward to legislate it?
I think what's going to happen is a letter that's going to be used, that can be used to prepare a memorandum. Well, when will we get the memorandum? You get the letter within a couple of days. The memorandum can be the subject of discussions that may very well produce a memorandum in short order.
Well, the shorter the order, the better, because it's a matter percolating and affecting a lot of people.
It does, and I don't minimize it. I think that we've tried to strike the balance with the McNulty memo. If we haven't, and there are ways to improve it, then we're bound and determined to improve it. And I think that letter will show that we are.
Moving to reporter's privilege in the limited time left,